cloning. It would be the 14th Amendment to the Constitution, deals with reproductive rights. It would deal with states banning reproductive cloning. That would deal with the 14th Amendment to the Constitution. If it was the 5th Amendment, it would be the federal government. 14th Amendment is the same, except it deals with the states. So clearly, there are these things in the Constitution that deal directly with science in a direct way. What about the 10th Amendment? Well, the 10th Amendment is very important because we have state laws on cloning. We have state laws that deal with science. We have state laws that deal with, regulating science in some particular way. And how is the state able to do that? Because the Constitution says that the powers not explicitly listed in the Constitution are reserved to the states or to the people. Yeah, Stephen.
I just want to add that the 14th Amendment, it basically imposes the Bill of Rights on the state constitution.
That's correct.
Also.
That's correct.
So like,
it's not really the Bill of Rights. We could debate that. It's really due process clause on the states.
The liberty.
But it doesn't have the freedom of expression. It doesn't have the freedom of religion.
It does.
I would debate that with you very strongly, but I don't want to do that now, okay? I would take very strong exception to that because most state constitutions have those things in them, but we can do that after class. In any case, the 10th Amendment reserves a lot of rights to the states, and that's where the states get their police powers to do all the things that we do in the state of California. That's where they get the power to make you have a driver's license. That's where they have the power to regulate, how you build a building or a house or whatever you do, but clearly it impinges on our rights in science because they can do things that deal with things dealing with science. And so again, how do these articles and amendments deal with science? I've mentioned some of them. Let me go over them briefly, again in the context of, for example, the federal police powers, which is promoting the general welfare. Notice, health, disease outbreaks, medical testing, drugs, food additives, release of GMOs into the environment, lab conditions, private DNA testing services, apparatuses, DNA databases, all these things we've talked about can be regulated under the promoting the police powers, under the promoting the general welfare. Intellectual property we're not going to talk about specifically today, but clearly we can have laws at the federal level that regulate genes, patents, genetic engineering, cell patents, copyright, software dealing with DNA analysis, biotech companies, drugs, all of these different things, because the federal government says what is patentable and what is not patentable, because again, that's a federal constitutional right. And again, we've talked about making all these laws, the USPTO, NSF, NIH, CDC, CODIS, again, Combined DNA Index Service for the FBI, all of this different stuff, the FDA we've talked about, the CDC, all of this stuff is making laws to execute the foregoing powers. Again, the same thing. If you look at the state funding, powers to the states and localities, and I'll get into that in a second, all of these different things, science, research, exploration, medical testing, food additives, release of things in the environment, state DNA databases, all of this stuff under the 10th Amendment, because those are not explicit in the Constitution and they're reserved basically to the states. How does the city of Cambridge then pass a law to ban genetic engineering? When they did, it's under a city charter. And you should all know that under our system, city charters are at the mercy of the state. In order to have a city charter, you have to get permission from the state. And believe it or not, the state can withhold or retract that charter if they would want to. They never would. But clearly, the rights of cities come under the rights and are allowed and given to the cities by the states. But that's a lecture for another time. Amendment 4, how does it deal with science? Body parts, hair, Samantha, saliva, new, blood, cheek, lab notebooks, records, probable cause, all of that stuff. It means that you can't simply go to the dorms and say there was this horrible crime and now I'm going to take the DNA of everybody who lives in the dorm in order to figure out who solves that crime, because clearly there's not probable cause to believe that everybody in the dorm did it without a search warrant. And so all of these things deal with Amendment 4. Who had their hand up? Julie.
Would that be exactly what they did in Europe with the...
They did that in Britain. not in Europe, it was in Britain. They went through a neighborhood, and they took the DNA from every guy. And it just so happened the first time they did that the guy knew that they were coming, and he got his friend somehow to give the blood. And so he escaped detection first time around. And it wasn't until another pass that they found him, but you could never do that in the United States. You can do it in Europe. Okay, state laws of DNA databases, there it is. We talked about that already. Again, might be unconstitutional. Now, here's the controversial one, dealing with science again. And I'm going to be more specific in a few minutes. We have the 4th and the 5th and the 14th Amendments. And these are the ones that get really controversial and have never been really tested at the Supreme Court level, or even the state Supreme Court level. But they deal with reproductive rights. And they deal with reproductive rights, as I'll show you at the end of this lecture, under the right to privacy and some really interesting case law that I'll share with you. But the point here is procreative choice, in vitro fertilization, stem cells, birth control, cloning, reproductive and therapeutic, and medical treatment. All of those things are rights under the 5th and 14th Amendment to the Constitution, particularly this thing called the right to privacy, which is not in the Constitution, which is an interpretive right that I'll get into in a few minutes. We've talked about slavery. I don't have to get into that at all. So the issue then is clearly, as I've said in perhaps overstated case on purpose here. You with me, Faria?
Yeah.
We can have laws that regulate science and the things that I do and things that impinge on your life. So, for example, all of us having to be tested when we're born. Again, that comes under the 10th Amendment to the Constitution, and it's something that the states can do to promote the general welfare. So, what about science inquiry? What about just thought? What about just theory? What about me thinking? What about Michael thinking? What about Stephen thinking? Can that be regulated? This is a really interesting point. Well, under the First Amendment to the Constitution, all of you in this room have the right to think. And you have the right to think about what you want to think about in any way you want to think about it. And you have the right, if it's in the scientific realm, which is what I'm speaking, to put your theories down on paper, as I've said, to publish those theories in a public forum, in a book, in a journal, in whatever, and to speak them and to give speeches, as I do many times. And none of that can be abridged by any law because it deals with the freedom of inquiry, the freedom of expression, freedom of assembly, and all of those different things. However, you have the absolute right to think. You have the absolute right to think about your theories. You have the absolute right, almost, to talk about your theories, not quite. You have the right to publish those theories. But Marvin, you don't have the right to act on those theories. Do you understand what I just said? You have the right to think, you have the right to talk, you have the right to publish, but you don't have the right to act. Because the act of experimentation is very different than the act of speaking. Because now you're doing something. And so therefore, if I do something in my garage or in my laboratory, it might put Albert or Taylor at risk. And so now I might be in the realm of affecting the welfare of the people around me. So the right to think is not the same as the right to act. And when you turn thought into actions, now you can come under very significant regulations and do come under regulations. So the extreme example would be that if you thought about making a bomb of some kind, you wouldn't be able to test it in your garage because people would be endangered. Well, it's the same thing, let's say, with recombinant DNA. If you think about recombinant DNA and you want to carry out a gene splicing experiment 30 years ago, some people say, well, you might create a cancer, or you might harm people, or you might do something. So you can think about it and think about it in theory, but if you actually want to do that experiment, we can pass regulations that would either regulate what you're doing or be able to prevent you from doing it because if it's under the First Amendment, it's under the Article 1 of the Constitution in promoting the general welfare, or it's under the 10th Amendment giving the powers to the state. So clearly, experimentation can be regulated and is regulated, and it's permissible and clearly logical that that should be. So in fact, Dora, you're correct that there should be regulations about experimentation in science because it could affect people around you, and therefore there are regulations, and therefore the NIH has regulations, the EPA has regulations, the CDC, all of these agencies have regulations, but they deal with regulating science in a very, 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 very strict way. Okay, so now let me just make a distinction here. How can science be regulated directly, and how can science be regulated indirectly? I'm making some distinctions. So science can be regulated directly under all of these things that I've been talking about in terms of promoting the general welfare. Science can, legislatures at the state, county, city, federal level can pass laws completely constitutional under federal constitution, federal law, state constitution, state law, city law that can regulate science because it's, again, in the realm of promoting the general welfare. And again, up here you can see if inherently hazardous to protect the welfare of the public and or the individual. So that's very clear and very important. So let me give you some specific cases. First case I've already talked about, and that is the Harvard City Council. Harvard City Council banned genetic engineering within its borders. They then amended that ban to basically say that way back when this technology was first evolving, you could do it, but you had to follow the recombinant DNA guidelines. And that meant if you were working with human genes, you had to do it under some very, very strict conditions. You know, rooms that were, you know, air didn't get out, that was filtered, and getting in spacesuits and stuff like that. It was pretty onerous, but you could do it. A little less so if you're just working with bacteria, a little less so if you're working with plants, but clearly this would stand up. If I, as a scientist, Bob Goldberg, said I'm going to challenge this city law in the courts, it would be struck down, my challenge, very quickly, because clearly they're trying to protect the health and welfare of the citizens of Cambridge. More recently, the ban on glowfish sales in the state of California. This was done by the California Fish and Game Commission, which again is a commission set up under the California legislature. And this legislature said we're not going to allow the zebrafish to be sold that's genetically engineered within the state of California. They did it for some weird reasons. It was more because they didn't like the fact that, you know, you could genetically engineer an animal. But the fact of the matter is there could be environmental concerns, could be, probably not. But because of those concerns, you can't do it. If you go to Arizona, you can buy the glowfish. Just don't bring them back into California. If you go to Nevada, you can get the glowfish, but just don't bring it back in California. But again, that's regulating science. Albert, can't sell it. What's up?
So it's illegal to even have a glowfish in California?
Yeah, you can have it, but you can't sell it, I'm pretty sure.
So you can
You
buy
could probably
it,
buy it,
somewhere else and
transport it.
transport
I don't really know what the law would be, but you can't resell it. And it maybe you couldn't, for example, go on the internet and say, I want to buy a glowfish. They're not going to ship it to California, that's for sure. Okay? But I'm sure some people have them. In fact, many people have them in their lab, but it's a different kind of glowfish. Genetically engineered rice in Kansas. There was a lawsuit to prevent farmers in Kansas from growing rice in the state of Kansas that would have a pharmaceutical or a drug in them. Well, the regulation said, sorry, you can do this because this is valid science. As long as this company follows these regulations, as long as this company does this, this, and this, and mitigates so there's no risk of this getting out, you can do it and it's allowed. Again, regulations dealing with science. Bioterrorism. If you're a researcher at UCLA working with a pathogenic organism, whether it's a mammalian pathogen, a bacterial pathogen, fungal pathogen, you've got to register your stocks with the government. And that passed after 9/11. and this is the Bioterrorism Act of 2002, and there's a lot of regulations dealing with science, mainly dealing with pathogens and how they're registered and how they're stored and how they're used and how you can get funding to work on it and a variety of things. But again, this is permissible. It's under a law of Congress, but again, it would be permissible under, again, the Constitution to promote the general welfare. California, most recently, as I showed you, human cloning. We have a law on the books that basically says that you can't have any reproductive cloning, but you can have therapeutic cloning. Would this stand up to constitutional muster? I'm not sure. It's debatable. But the fact is that there's a law, as Korobkin said on Thursday, there's a law that says that you can't sell your eggs for use in stem cell research. That's a state law. That is a law that impacts science, and it's perfectly permissible. The argument for prohibiting reproductive cloning is simple and logical. Again, it says that if you can't guarantee that the kid is going to be just as 100% chance of being normal as doing it the normal way, you can't do it. And that's logical, again, promoting the general welfare. So that's another specific case. So again, laws exist that regulate science at the state level with respect to cloning. In vitro fertilization, another law, which we talked about paying for eggs for stem cell research and a variety of other things that deal with in vitro fertilization. Again, these are laws. Now, again, I'm not a constitutional lawyer. As you can see, Stephen and I disagree on certain things. That's like all constitutional lawyers. You're never going to get two of them to agree on the same thing. And in fact, as you know, there's many debates in this country, particularly dealing with the abortion issue, and those are constitutional issues that some people come down on. And as you know, our Supreme Court is split between the strict constructionists, more the conservative, somewhat in the majority these days, and those that believe in a more loose ability to interpret the Constitution. So let's say, where does the 14th and 5th Amendment to the Constitution come in with respect to therapeutic cloning and reproductive cloning? I don't know. I wouldn't have a clue. But I do know that those amendments, particularly the 14th Amendment, as I said, gives a woman the right to procreative choice up to the second trimester. So it's a constitutionally protected right. And how is that right given? By a very famous case called Griswold versus Connecticut. Estelle Griswold was the head of Planned Parenthood in the state of Connecticut. The state of Connecticut, in their wisdom, banned all use of contraceptives by married individuals or single individuals in the state of Connecticut. It was a state law. We all laugh now. How is this possible? You've all heard about the abortion debate. You've all heard about the right to privacy. That's where it began, right over there in Griswold versus Connecticut, because this thing called the right to privacy didn't exist before Griswold versus Connecticut. Connecticut, the state, Estelle Griswold brought suit against the state and said this violated the Constitution because the state was taking away our due process to life, liberty, and pursuit of happiness, which the state can't do without due process of law. In this particular decision up here, Griswold versus Connecticut, Justice Douglas, who was one of the most famous justices of recent times, William Douglas, basically said, as you can read here, that the right to privacy means anything. It's the right of an individual, married or single, to be free of unwarranted government intrusion into matters affecting a person as to whether or not to have a child. Basically saying that the government can't get in someone's bedroom and tell them that they can't use contraception. And that all of us have an inherent liberty, even though it's not explicitly written in the Constitution, we have the right to privacy, that it's inherent liberty. What could be more important to us than the right that we have to privacy of our bedroom, and particularly the privacy of reproductive rights? Now, people who are on the other side of the pro-life, which I find sort of a oxymoron, or the abortion issue, would probably take exception to this and say these activist judges put the right to privacy into the Constitution, which was not there. Again, I'm not going to argue either one way or the other because I'm not a lawyer. But the point here is that there's a zone of privacy created by several constitutional guarantees with the aspect of privity as predicted by due process clause of 14th and 5th Amendments. If a law against a totalitarian limit on family size, that's saying only people can have 1 or 2 kids, is a complete variance with our constitutional concepts than a law outlawing birth control is. Griswold versus Connecticut established the right to privacy. There were other cases that I'm not going to get into, believe it or not, that overturned state laws preventing single individuals from using any form of contraception. Believe it or not, those laws were on the books. There were other laws that were struck down that said people of different races couldn't marry and have children. What an enlightened country we live in. A law that says people of different races can't get married and have children. There were other laws that were struck down that said people of the same sex can't use contraception or any means of protection, that were struck down. All in this period. All establishing, all establishing again this zone of privacy. And out of this zone of privacy came this very famous case. How many of you actually read the entire case? In this room, you've all heard of Roe v. Wade. Probably one of the most controversial Supreme Court cases of the last 30 years. How many of you actually read it? Well, I urge all of you to, because if you read it, you're going to see that it's awfully moderate and quite well reasoned. The point here is that Roe v. Wade gave the right of a woman to terminate pregnancy in the first 2 trimesters. And so the point here is not that I'm going to get into this debate, because I'm not going to, but the point here is that there is a right of procreative choice. The question then is, if, for example, reproductive cloning were 100% successful, the question being, if all of you could give rise to clones that would be 100% healthy as compared to normal children gotten, let's say, the normal way, whatever that means in our context. Remember, in vitro fertilization prior to 1972 wouldn't have been considered normal. Catholic Church still doesn't consider in vitro fertilization to be normal. The bottom line is whether or not these would be upheld to be constitutional or not if there were laws passed, as there have been, to ban reproductive cloning or even therapeutic cloning. The point here is that one doesn't know. We can only reason. And it would only do with what the court says. That they deal with science, and they deal with issues that are very important. And as I said in the beginning of this lecture, the law has to move as technology and science moves in some particular way. Stephen, science issues.
I just want to correct you on a fine point that that
Stephen, let's debate after class because we may have a different of opinion on this. Okay, go ahead.
Correct.
So let's say my opinion on this is that, not correcting me.
Oh no, it's
go ahead.
A case that happened after Roe v. Wade.
Yeah.
It was Planned Parenthood v. Casey, and
that's a really later case.
It is.
That's 30 years later.
But it redefined. It took out the trimester framework from the abortion argument, and it just says that it's viability that's the time limit now. When the fetus is viable to live.
If you read Roe v. Wade, that's what's in there.
No.
It's called quickening.
Roe v. Wade is a little bit different.
Stephen, I admire your courage, but I disagree with you. If you get it out, I will show you after class, okay? It's the period of quickening, okay? And quickening is defined by viability. And Luckmann, who wrote the decision, basically said that no one can define when a child would be viable or not, but we will use the traditional Judeo-Christian definition, which is quickening, which is after the second trimester in which the child would be viable. That's how it reads.
The
Anyways,
case I
Planned
referenced.
Parenthood versus Casey is a whole different matter. And let's just say I would invite you into my office hours on Friday, and we'll go over every single solitary constitutional case that deals with reproductive rights.
I work on Fridays.
Okay, well, you can come in another time. I'd be happy to do it. Okay? In any case, it's a moot point. I think that there's many cases that deal with this issue, and many of these cases deal with, you know, the welfare of the mother, which is now one of the most overriding issues, because abortion laws have been becomingly more and more restrictive at the state levels, but I think it's the rights of the mother. But those are other issues, honestly, that you can debate in your political science classes and your history classes and your reproductive rights classes, but the examples that I'm giving here deal with science issues. And whether or not one can use this to ban, in any case, cloning or not, I don't know. But what I do know is that these issues have to evolve. And they have to evolve as technology evolves. And they have to evolve as the science evolves, because the issues become new. They become new as there's new things that come about. So that allows me to segue very nicely into how we can regulate science in an indirect way that has nothing to do with any laws per se. How can we regulate science in a very, very, very indirect way? Because I think it's obvious that we can do it in a direct way. And that is, we do it through the power of the purse. And that is that no one can really do science unless they have some cash in their bank account. And there's the rule called the golden rule, and that is, he who holds the gold makes the rules. And therefore, if you're getting money from somebody, you've got to follow their guidelines. And if you don't want to get that money, then you don't have to follow the guidelines. But as long as you're going to accept the cash, you better do what they're going to tell you to do. And this becomes into play with recombinant DNA. Because even now to this date, if I send in a grant proposal that has to be signed off by the university, I can't send it in myself, because my grant proposals and Dr. Harada's grant proposals are sent in on behalf of the University of California, not me. I got to have someone in some office sign. And that person who signs has to make sure that I'm not in violation of a number of different things. One, I'm not in violation of recombinant DNA guidelines that pertains to the science in the grant proposal. So if I work with plants, I have to say, well, I did this, 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 and the biohazard committee people have signed off on it. If I'm working with humans, I have to follow the institutional review board, the IRB, and I have to have a protocol saying it's been approved by the Human Subjects Research Committee. If I'm working with animals, as AICHA does, the grant proposals have to be signed by the committees that deals with animal research. And all of these things have to be signed off, Maura, on the grant before I send it in. And unless you follow those guidelines, you ain't going to be able to even send the grant off in the mail, and therefore you're not going to get any money in order to do anything. And so therefore, the funding right is the way in which, for the most part, at the federal level and at the private level, science is regulated. And what I mean by that is that there's certain conditions that you have to follow in order to do what you're doing. And so, again, recombinant guidelines or whatever guidelines that you're using in order to do it. So, for example, stem cell research, you would have to follow certain guidelines if you're taking state California money for stem cell research or private money for stem cell research. In order to even get a grant, you'd have to follow University of California, Los Angeles, or Davis, or any campus's rules, which again mean protocols, institutional review boards, consent, all of these different things in order to be able to do what you're doing. And again, there's other kinds of conditions. If you're going to field test crops that are transgenic, or if you're going to field test animals that are transgenic, you'd have to follow the guidelines of the EPA and other agencies if you're getting money for them, and a variety of different things. So in a sense, that's the way in which funding is regulated indirectly. And in my early days, and including now, when I wanted to get money for research, I had to fill out this form. And I couldn't get my grant off campus unless it was approved by this individual down here. There's an interesting story to this. Down there that was signed off in terms of working with recombinant DNA. What do you think about that, Kathy? So my hands are tied.
What do I think about what?
Having to go through all this stuff in order to put a grant in.
Well,
Or do you think I should just be able to put that grant in any kind of what? Just do it.
no, it makes sense this way.
Makes sense?
Yes.
Pain in the butt. What do you think, Samantha?
I think that it's necessary because I feel like although you might be very trustworthy and you know what you're going to do with all this money, there's so many people, and there's only so much money, especially at a public university like this, where we only have so much money.
But this doesn't have anything to do with money. This has to do with regulating science.
But you
It's
just said a
nothing to do with
grant.
so much money. It has to do with regulating science. Forget the money aspects.
But that's the whole reason, maybe that's why it's there.
It's not there. It has nothing to do with money. It has to do with you carry out experiments safely.
This is, you said this was a grant though, or is this just a biohazard?
It's,
This is an approval.
it's a regulation that you have to follow in order to get your grant funded.
It's just the liability of the university.
It doesn't have anything to do with liability. It has to do with carrying out your experiments properly. It has to do with following the recombinant DNA guidelines
But
and
you're
doing
on
the
their-
experiment. They're
but
not
you're-
worried about liability.
But you're on their property.
They're not worried about liability, I can assure you of that.
Really?
Yeah, it's not a liability issue. Stephen?
Would you be required to do that if you were applying for a private grant?
Yes. Absolutely.
I don't understand that.
Well, because generally private companies will follow the recombinant DNA guidelines because it's logical, because this is the way in which one can protect people around you and do the science in the proper way. It's a sort of a bureaucratic thing that can regulate, again, how you do science to make sure that we do things in the most effective and the safest way and to mitigate any sense of harm. The point here is that one can regulate science in an indirect way. And so the summary of all this is, going back to the history, yes, recombinant DNA is a new technology back then. Yes, there are new technologies now. And yes, there can be laws that can regulate those technologies. And those laws are permissible under our form of government at the federal, state, and local level. But in most respects, the majority of regulating how science is carried out is done through the power of the purse. And that is following regulations that are put into place to make sure that the environment is protected, to make sure that your lab is protected, to make sure that you do things in a proper way through the power of funding in many, 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 many respects. And so it's an interesting set of laws, but in many respects, all of us have to abide by these things. Those of us who are doing science have to abide by them because they're logical. We can't challenge them in the court. Go ahead.
Okay, so I'm just confused still. I was talking about liability, and you said it's not
It
liability.
has nothing to do with liability. It has to do with sound laboratory procedures. And, you know, has to do, people, when they were doing recombinant DNA in the early days, Samantha, they weren't concerned about being sued. They were concerned mainly that maybe someone would get cancer or something like that. So it was more the health and welfare of the people around them rather than legal issues. So the issues were much bigger than simply, you know, am I going to get sued or something like that. So in the sense of these regulations, if, for example, I'm working with a transgenic pig and I want to do it in the environment, the regulations would say you have to have a pen, it has to be enclosed, you have to have barriers to prevent it to get out, and in some respects that would be protecting the environment. So a lot of these rules are just logical from the point of view of protecting either the environment or society or the lab and doing things under the proper conditions.
I'm just wondering, let's say you had some kind of experiment, you did something in your lab, or any of your students did something in the lab, and it was very deleterious and something really bad.
Wouldn't happen, so don't use me.
Okay, in a
And
hypothetical
it
situation
probably
with another,
wouldn't happen. Yeah, it could happen. Yeah, go ahead.
would the
I know where you're
university get
going.
in trouble?
Would the university get in trouble?
'Cause
I think in our society, anyone has the ability to get into trouble for doing anything, okay? So any of us can get into trouble for anything that we do, yes. That could be an issue. But
I know of a case that happened, we were talking about it in our discussion at UC Irvine, a bunch of scientists that had donated eggs.
I know all about that case, yes. But that was criminal neglect.
Okay.
That was a crime. They were basically using somebody else's eggs and putting it in someone else without their consent.
Yeah.
That was criminal. That had nothing to do with carrying out science.
But
that's a different issue.
That's a different issue?
Totally.
Okay.
Totally. I mean, I hope no one's carrying out, illegal things in laboratories anywhere, but that's just different than what's being tried to do here. Any other questions, issues, comments? You okay, Eden? You happy with this? You have a problem? Pardon? You can do whatever you want. You don't need to raise your hand like, get a note from your mom or something like that. Okay. God, she really has to go. Any questions on any of these laws or regulations or comments or dissensions or anything else? Derek? Happy? Faria, you happy?
Yes.
Did you know all about this stuff before I talked about it?
Some of it.
All of it?
Some of it.
Huh?
Some of it.
Did I waste my time?
No.
Okay. In any case, let's just talk really where science hits the road with respect to biotechnology. So let me then make the transition to the issue of who owns your genes. Now, I already said earlier that 20% of your genes have been patented. And that conveys a certain meaning that I'll get into in a second. But the fact of the matter is that in reality, no one owns your genes except you. Stephen, you own your genes. In your chromosome, no one can own your genes, no one can own your cells, no one can own your RNA, no one can own anything, as you will see in a second. But as I also showed you previously, in the Constitution, one can patent things. And clearly then, with respect to genetic engineering, when it was invented, it raised some new issues. Because prior to the invention of genetic engineering, no one could ever think about patenting an engineered cell, because no one could do it. Except that's not really true. There was a thing called patenting hybrid crops. In other words, in the 1930s, people learned how to breed for hybrid crops, which was something that didn't exist in nature, that was made by man. Hybrids were made directly and intentionally. And so these were really, in some respects, the first patents which were allowed on a living entity, so to speak, because the U.S. Patent and Trade Office and Congress basically said, well, you can have patent protection for hybrid crops. But clearly when genetic engineering came into play, the whole ballgame changed. And clearly when stem cells came into play, the whole ballgame changed. And all of this technology led to very, very novel issues with respect to intellectual property and all these other things. So as I said, no one owns your genes, no one can own your genes, no one can patent your genes, but one can patent certain aspects as long as something is done in some way, as you will see. So this deals with intellectual property. And there's the reading. If you want to read it, it's on your handout. There's some wonderful stuff that you can read with respect to patents. It's very clear, but one can do that. So as I said several times today, the only place that science is mentioned in the Constitution is with respect to patents. Patents and copyrights to promote the progress of science, to secure inventors the rights of their discoveries. One can have a patent. So any of you can file a patent on any of your inventions if it follows a series of criteria, and doing that is a federally mandated constitutional right. And as I said, if you don't like the patent laws that are passed by Congress, you can go through the federal court system, or you can get your Congress people to change them, and they do. And the federal courts do come down on that, and the most famous one is a case which we'll talk about, Chakrabarty versus the United States, which dealt with patenting genetically engineered organisms. Now, with respect to patents, as you see in the slide, it's important to keep in mind that the Congress passes all laws dealing with patents and copyrights in the United States. What that means, Albert, don't wander on me, what that means is that the states have nothing to do with this. There can be no state law dealing with patents. There's no state laws dealing with copyrights. There's other state laws dealing with other kinds of things, but no state laws dealing with trademarks, no state laws dealing with copyrights, no state laws dealing with patents. There are some state laws dealing with trade secrets and stuff like that, but I'll talk about that in a second. And that also means that the federal judiciary under Marbury versus Madison is allowed to interpret the patent laws of the Congress of the United States. And of course, the president has to sign these laws before they go into action. And so all of this stuff applies to patents and it applies to biotechnology patents, but in a way, Congress passed the laws dealing with patents and copyrights. Congress set up the United States Patent and Trademark Office. The United States Patent and Trademark Office sets about, setting about rules of what can be patented and what can't under the guidance of Congress. These get signed into law. They can be changed by an act of Congress and only by an act of Congress, or interpreted by the federal courts. And of course, the interpretation of the federal courts comes into play because how can one decide whether a living cell or a gene or a switch or anything can be patented because it didn't exist when Thomas Jefferson set up the patent office in 1793. And so clearly there's the first patent, as you can see, patent number 1. You can see this in the National Archives. You can see the signature, George Washington. This is something that was set up very early in our history, but goes back to English common law. Patents have been around for a long, 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 long time, 400 to 500 years. And there's a concept behind patents, and it holds to this day. And the concept goes like this. If you invent something that's useful for society, in which society can benefit from, the idea, Stephen, is to get it out into society. The idea is not to have you keep it in your garage and not share it with anybody. Because there's a lot of inventions that are made that have facilitated a tremendous amount in society. Like the Apple computer, like genetic engineering, like millions of things you can think of. And how tragic it would be if your invention just stayed in your garage and didn't go anywhere because you were afraid that someone would steal your invention and you didn't want them to do that. So going way back, way back, to 14 and 1500s, it was recognized that inventions are valuable. Inventions are valuable because they can progress society. Inventions are valuable because the people that make these inventions can teach society how to do things that they didn't know how to do before. And inventions were important, and in order to get the inventors to teach society their new processes, contribute their new machines, do all these new things, society made a compact between the inventor and itself. And the compact went like this, and it still exists. We know that you have this great invention. We know that it's going to be useful for something that Brian might do. And we know that you need some consideration in order to give it to us. We need to give you something. And so the concept was that society will give you a grant, a monopoly, on the use of your invention for a certain period of time. And now it's 20 years worldwide. So you can have an exclusive use to your invention for 20 years. Doesn't mean that you can make a business or do anything. It has nothing to do with that. It simply means you can exclude somebody from practicing your invention without giving you some money. And that's what was conceived several hundred years ago. But in return, you have to give something back. And here's where it really works. In return, you have to teach society how to practice your invention, which means you have to publish it. You have to make it available to society so that at the end of your monopoly period, anyone in society can practice your invention and do it for free. So there's a compact here. The compact is between you and the inventor. It went back to stained glass and even before. It went back to England, it went back to Europe, it went back to Venice, it went back to the 1400s and 1500s, where the society said, teach us how to make this kind of stained glass. Teach all of us. Tell us exactly how to do it. But in return, you can be the only one that can make that kind of stained glass for, let's say, it may have been 16 years in those days or 20 years, and then you have a monopoly on that process or that invention, and if anyone wants to practice, they've got to pay you some money. It's like you have to license it. And that's how it works. And the idea is that it, again, promotes the progress of science. Because out of that, and I disagreed with Koropkin on this on Thursday, but I didn't want to debate him in class because we didn't have time. Out of that, when you publish your invention, other people can read it. And by reading it, they gain knowledge. And by gaining knowledge, they do more inventions. And those inventions, if they're different from the one which they read, can be very new, useful, and novel, and be the source of another publication. Case in point, recombinant DNA. Think about all the knowledge and all the things that have come out of genetic engineering, recombinant DNA, Cohn-Boyer, and that is a patent, the Cohn-Boyer patent. But anyone who used it paid a small fee in order to be able to use it, and think about all the knowledge that came out of that particular patent. Another patent, which you'll have as a handout when you leave, the Carey-Mullis PCR patent. Anyone who uses a polymerase chain reaction to this day pays a royalty. How do you pay it? You pay the royalty when you buy the PCR machine. You pay a royalty when you buy the reagents to do PCR. You pay this royalty because the patent is still in play. But think about all the great things that have been done by people using this particular invention, and so on and so forth. And so the idea is that you transmit knowledge to society. Society then in return gives you something back in terms of limited use for a certain period of time. And I'm not going to go over this because I just did. So the question then is that in order to have patents, as you know, and we discussed in this class, and as I showed in a clip, this is the way in which you can establish business. Because no one, I can assure you, will give you one dime to start a company, not even a penny, unless your inventions are secured by a patent. So if you think you want to start a company, that you're entrepreneurial, if you don't have patent protection on anything you're doing in that company, no one's going to give you 1 cent. Small company, big patents. Big patents, that's what you're worth. That's all you have. You don't have any products. You have intellectual property. Why is someone going to put money into that? Because they think that eventually you might make a product and that product will be protected by your patent. And therefore, Carey-Mullis invented the PCR reaction. He was working for Cetus Corporation. You saw in the Carey-Mullis, he said, if you ever get the chance, have your name as the assigned to rather the inventor. Remember he said that because that's where you make all the royalties. Well, in fact, if you have a company and you're inventing things, it's assigned to the company, and then people that invested in the company will know that you'll be able to eventually make some products, and those products will be able to be protected from some other company doing something. And so there's the biotech industry, which started with Genentech way back when, and it's probably even bigger, although the value might have dropped because of the drop in the stock market, but let's say about $400 to $500 billion. That's a lot. There wouldn't be 1 dime of that money if there wasn't a thing called patents and there wasn't the ability to protect inventions by patent technology. And here's the number of companies. It might be more, it might be less, but many of those and most of them are in California. So the questions related to genetic engineering relative to patents are on the board here. You can read them, but let's just say, is one of your genes patentable? The answer is in your chromosomes, no. In a plasmid, yes. And I'll tell you why in a second. Is your switch patentable in your chromosomes? No, but in a plasmid, yes. Is genetic engineering procedure patentable? Absolutely. Cohn-Boyer, transgenic plants, transgenic pigs, stem cell research, all of that stuff is patentable. Can a process of making human embryonic stem cells be patented? Absolutely. Can a living organism be patented? Absolutely, and has been many times. Can a DNA sequence be patented? Absolutely, outside your body. Can it be copyrighted? Maybe. Maybe not. Can a DNA sequence database be patented? No, and I'm going to get into all the reasons why. But the fact of the matter is that we would not have this industry and not have learned an awful lot without these patents. Is that clear? Lauren, is it clear? Albert, hit me.
How do copyrights work?
We're going to get into that, okay? I'll talk about that. I'll tell you exactly how it works, okay? I'll talk about trademarks, I'll talk about copyrights, I'll talk about patents, because they're all forms of intellectual property, okay? So one of the things that distinguishes our patent system, and it relates more to stem cells and patenting genes and things like that, it differs from Europe, European Patent Office. Europe has one patent, they're individual countries, but it's mainly under the European Patent Office, which is part of the European Union. Our system is morally neutral. You want to invent a bomb that can blow up the earth? Go right ahead. We do not make a distinction between whether that patent is useful or not in terms of from a moral or from a judgmental point of view. So therefore, we do permit patents on stem cells. We do permit patents on human cells. We do permit patents on transgenic pigs. In Europe, they wouldn't allow such patents. They have some clauses, as you can read here, that are governed by certain sense of morality and public good. And in fact, the Wisconsin stem cell patents weren't accepted in Europe, but were accepted in the United States. Albert.
So in general, do U.S. patents, though, get accepted in Europe? Or could someone in Europe just say, well, this isn't patented here, I'll just patent it?
Okay. That's a good question that I'm going to get to. Patents are country specific. If you have a patent in the United States, it's only good in the United States. If you want a patent that works worldwide, you have to get a patent in the US, you have to get a patent in the European Union, you have to get a patent in Japan, you have to get a patent in China, you have to get a patent in Brazil. Wherever you want to practice your business and get protection, you have to have a patent in that country. So there's no worldwide patent. The only way patent laws are governed worldwide is through GATT, the General Accord on Tariffs and Trade. And so you could be sort of deemed to be violation of GATT, but has nothing to do with patent law. Patent law is country specific. And generally, if you have a really valuable invention, you'll file it where you think you do business. And where you would file for patents would be in the United States, Canada, European Union, Japan, maybe China, it depends, probably China in this day and age, but in the old days, no. Maybe a couple countries in Brazil, depending upon what your business is. But you wouldn't do it in every country. You wouldn't do it in Guinea-Bissau. You wouldn't do it in Malawi. And it's a very expensive process. Thomas.
How do they determine whether or not it's exploitive to public policy and morality?
Yeah, I think that's a really good question. I think it just interprets on the basis of what this patent commission deems to be, within public policy, public good, public morality. It happens to be in Europe that they don't believe in having a patent on anything that was derived from a human being. I mean, that's what they feel. Human beings shouldn't be patented in any particular way. We don't really look at that except the human being as a whole. Eden? Dora, do you have any questions?
In the
No.
European
Go ahead.
in the European Union, if it's an invention that's not if it's moral to make it, but what about if like the next invention? Like,
You have to give me a specific example.
okay, let's say
Deals with human beings.
just with human beings.
Yeah, because that's really, you can have a transgenic tobacco plant. That's okay.
Okay, I was gonna say more with like a bomb or something, but never mind.
Yeah, I mean, I can't comment on a bomb per se, but remember, we saw a clip that there is a patent on, of course it was in the old days, but there is a patent on a chain reaction. In the United States, you can have patents on these kinds of things to a certain extent, except for nuclear weapons. That's not permissible under laws of Congress. Okay, let me just see where I am. So there it goes for the European Union. Processes for cloning human beings, germline genetic identity of human beings, et cetera, et cetera. You can read it. But the point here is that we have differences in policy. Okay, let me just wrap this up for today with this. In 1980, we talked about this in class. Go back to your lecture number 7, Applications of Genetic Engineering to Bacteria. We talked about engineering bacteria with different plasmids that put together novel metabolic pathways in bacteria. And I won't tell you, I could have put the slide up, but I didn't. But there's this guy, Chakrabarty, Ananda Chakrabarty, who happened to engineer a bacteria with a certain number of genes that it wasn't born with, so to speak, in which the metabolism of that bacteria was engineered so that it could degrade oil, a pollutant, so to speak. And his idea back then was with an oil spill, you'd dump these plasmids, these Pseudomonas plasmids, into the oil spill and it would just eat it up because now it lives off of these hydrocarbons. And he filed a patent on this particular organism, genetically engineered. The United States Patent and Trade Office rejected his patent. He was working for General Electric at the time. His patent, but it was part of General Electric. The USPTO rejected his patent, and because these are governed under federal laws, Chakrabarty said, you can't reject my patent because this particular bacteria doesn't exist in nature. It never existed anywhere. I made it with my own hands. It's an invention. It's no different than making a machine. It just happens to be a cell, but it doesn't exist in nature. And this case went all the way through the federal system and went to the Supreme Court of the United States. In one of the most important decisions, if not, I would say, the most important decision relative to genetic engineering and the law and biotechnology, this decision, Chakrabarty, 1980, the Supreme Court said living organisms can be patented. As you can see, that's headlines from the New York Times. Science may patent new forms of life. And that pertains in the United States to stem cells because there's Jamie Thompson's stem cell patent, as you can see, and a variety of other different patents. And the reason why is that the Supreme Court said that Chakrabarty's bacteria was a human manufacture. And Chakrabarty's bacteria was made by the hands of man. Anything under the sun, they said, anything under the sun made by the hands of man is patentable material, and therefore upheld Chakrabarty's patent on the oil-eating bacteria. And that patent set in motion the start and the success of the biotechnology industry in the United States and around the world. So you can patent a mouse in the US, a genetically engineered mouse, a genetically engineered plant, genetically engineered stem cell, a genetically engineered cell, genetically engineered bacterial cell. You can have patents because it was made by the hand of man. And the Supreme Court acknowledged that science is moving, and as Jefferson said at the beginning of this lecture, science is moving, and therefore the laws have to move to meet the needs of science. Any further questions? Julie.
they demonstrate that the bacteria actually worked on an oil spill?
Yeah, it did in a lab, but not in an oil spill. Because then you have other kinds of considerations, because you have environmental considerations and all the testing that has to go on to do that. So it didn't turn out to be a very practical invention, but it was a novel invention. Okay. I'm going to wrap all of this up on Tuesday, and you'll see with a really interesting conversation on copyrights, trademarks, and patents. Before you leave, you'll have a packet. In this packet will be, I want you to sit for a second, Samantha. I know you're tired and have to pee. In this packet will be your final oral exam. In this packet will be a couple of real patents. In this packet will be the gene therapy articles for next week. Okay? Now, unlike your take-home exam, you must, Dora, are you with me?
Yeah.
You must start on this final oral exam today. Albert, you're not going to be able to do this the night before. You're going to see stuff on there that you've never seen before. So, as I told you last week, it's a very simple way to do this. Let's say I got this thing today. If I had some spare minutes, I'd look at it and I'd read it. And I'd say, oh, lecture. I'd go, oh, discussion. I'd go, book. I would just try and organize those questions with respect to where you might find the information, Scientific American article. And I would just jot it down and organize in my own head where you'd have to look to get the information. Start that way. Don't start in a group of 56 people and say, you do this, and you do this, and you do that, and you do that, and you do that, and you do that. First, organize where the information is that you need to answer those questions. Try and organize the questions a little bit on your own, and then get together with your groups in terms of trying to answer them. If you follow that method, I think you'll do much better than you did, which you did well, but you do much better than you did on the previous exams. But more than that, it's going to be a lot simpler for you than the process that you use going through this first. Okay? So why don't you get these things? And one last thing, and I appreciate your patience, I really do. You'll be, well, Ingrid and I are cooking up something, so don't worry about it. Aren't we, Ingrid? In any case, I don't know how John's going to do, John November, on Thursday. Just as you did with Russell, who turned out to be pretty good, except he got bogged down on selling the eggs. But other than that, bombard John with a lot of questions. But what I'd like you to do is to bombard him with practical questions. How do you get the DNA samples? How do you go to these people in these different locations? How do you persuade them to give their DNA and all of these different things? Ask him more about sort of the nitty-gritty, because I think you know about most of the science that he's going to talk about, okay? I'll see you guys on Thursday.